chairperson designee of the New York City Law Board. I would like to welcome you to our January 21st, 2016 public meeting. We first turn to a vote on the minutes from the November 19th, 2015 public meeting. Are there comments or corrections to the minutes? Does anyone move to accept the minutes? Do I have a second? Thank you, Chief. Ms. Rivera, can you pull the minutes? Oh, I'm sorry.
Mr. Bowling?
Yes.
Chief?
Yes.
Chairperson?
Yes.
Mr. Delaney?
Yes.
Ms. Bolton Rivera?
Yes.
Mr. Jackson?
Yes.
Ms. Shelton?
Yes. And that was Ms. Shelton who was the first. I apologize for
Yes.
rushing through it.
7:50.
Thank you. Lanny Alexander, our Executive Director, will now give her report.
Good afternoon, everyone. As of today, the Law Board has docketed 29 coverage applications since the legislature amended the law, temporarily lifting the statute of limitations. I sent you information regarding the building milestones for the buildings in our jurisdiction, as well as the hearing report. I just wanted to note that as of today, we have 332 buildings in our jurisdiction. 231 of those are the old buildings, the 281, 1 and 4 buildings, and 101 are the new buildings, the 281 and 5 buildings. And I wanted to parse out the new buildings to show where they are in our milestones. We have 6 who have already gotten certificates of occupancy. That's 3 up from November. We have 4 of the new buildings that have TCOs, and that's 1 down from November, because of course 1 went up. We have 11 who have permits, that's 1 up from November. 7 buildings have finished the narrative statement process but haven't pulled their permits, that's up 3 from November. We have 37 buildings that are in the open narrative statement category, and that's up 3 from November. And we have 12 buildings that have filed their Alt 1s, that's down 1 from November. And we have 24 buildings that have not filed anything yet, and that's up 1, and that's because we received a new building this past week. I just wanted to make some staffing announcements as well. Last month, Faika Ahmad, our project manager, moved from the Law Board to the Brooklyn Borough office, and she is now an assistant plan examiner. We are very happy for Faika, and we wish her much success in her new position. As she is an architect, you know, this is a very good thing for her. Tomorrow, unfortunately, is Deborah Fremder's last day with us. She's going to be moving over to the Department of Environmental Protection. And we want to take this opportunity to thank her for her years of service with the Law Board, as well as her service to DOB. She was one of the people who twice assisted in the code revisions for DOB, and we also wished her much success. Both of these vacancies have been posted, and in addition to these 2 losses, we have had we've tried a new avenue of employment recently. We have the rent adjustment applications, those are, we call the pass-along costs, that have been pending for a while, and thanks to Alex's very good idea, we have hired 2, they're called reserve employees. These are employees that are retired, who are placed through reserve. They work part-time, and these 2 are accountants. And we're really happy to have them with us. One of them is, I believe, with us today. That's Thomasine, she's over there. So we're reorganizing the forms for that, and the 2 of them are digging in for that. And we still have our wonderful college intern, Elaine Kong, who was with us for a good portion of the Christmas break, but unfortunately has had to go back to school. Finally, I sent you the year-end information regarding the Article 78, and if you have any questions, I'll be happy to answer them. And speaking of questions, I just wanted to note 2 things. well, one thing, which is that two of the board members gave me a call because they had some questions. And this was a really terrific thing for them to do because that gave me the opportunity of sort of looking deeply into what they were asking, figuring that maybe some of you also had the same question. So let me take this opportunity in my remarks to address those two. Mr. Schachter was inquiring as to the fact that it appears that we just deny extension applications, because that's what you see. And he wanted to know what the standard was, what the process was, and you know, I think he understood the law, which was that we have certain timeliness requirements, and then the two-pronged requirement of showing good faith, attempt to meet the compliance deadlines, and that the delay was not the caused by the owner. What I wanted to say about that was that for the most part, we're not getting extension applications from the old buildings because all of their dates, their compliance deadlines have passed. And you cannot ask for an extension for a compliance deadline unless you're a new owner. So in the case of a new owner, we give it to them. You just don't see it because they don't appeal that. It's an administrative decision. It goes out, nothing happens except they get the extension. The same is happening with the new buildings. Unless they file timely, in those cases where they're just coming into our jurisdiction, they're not going to get an extension application, an extension granted, except, of course, if they're a new owner. So that's why what you see is in the appeals is the appeals for the denials. The second question was from Ms. Bolden-Rivera, and that was about the summary cases. And she noted that some of these cases seem to be a little bit old. And why were we only getting to them now? So it gives me the opportunity to remind you that in general, we take these summary cases by age, how long they've been with us. We also try to bring settlement cases for the same building at the same time. So if we have one that's in and one that we know is coming, we're going to hold one until we can get them all together. The other factor that we have in not being able to take a summary case and just bring it to the board is that often the settlement involves either the owner registering, the tenant vacating, or the owner paying the tenant some consideration. And so, for the most part, our delays are in our efforts to confirm that these things have been done. So, for example, if it's a registration, we will not bring the summary case to you until we add the building registered. If it is a vacate, we will not bring it to you until we have a verification from the attorneys or from the tenant, if they don't have an attorney, that they have indeed vacated the building. So for this month's agenda, I looked at all of the cases. We had 9 cases. 5 we held to confirm the vacate. And in most cases, we didn't confirm the vacate until December or November. 2, we waited for registrations. They happened in December. 1 was a mistake. It should have gone in November with its companion case, and that was an oversight on our part. And 1 is very recent. So it would not have shown up, it wouldn't have come in its queue. So that's why these cases are that appear to be old, the settlement that happened in 2014 and only now comes to you. That's why. So I want to say that I'm grateful for anybody calling with questions so that it gives me an opportunity to make sure I have a cogent answer to give to all of you. So thank you both. And I think that is my report.
Thank you for listing the fact that 29 coverage applications have come in since the filing deadline was temporarily extended. Do you have any sense among those as to whether there are additional units in buildings that had already filed for coverage, or are they entirely new buildings?
My sense of the entirely new buildings.
Not For the most part,
Yeah.
yeah, okay, great. And secondly, I think it's very helpful to report on the fact that we see these extension denials because those get denied and in this case appealed, so it appears on the reconsideration calendar. And this really goes back to something that I had raised a few years ago, I think, which is perhaps every 6 months or in the annual report that you provided us, which is helpful and a new initiative, I think it's fair to say. It would be extremely beneficial if at some point we could kind of get an accounting of how many extension requests were made, as well as just seeing the ones that were denied. I mean, did you grant 10 extension requests last year or 100? Do you have any, can you just give me a ballpark?
No, I can't. I would prefer to go back and give you the accurate amount.
Do you get a lot of them?
Not so much anymore. We used to,
Mm-hmm.
but not so much anymore.
And a lot of them are based on new owners?
They would either be based on new owners or they would be based on the fact that they've just come back, they've just registered the building, which
Okay.
is what happened.
So would it be fair to ask for maybe?
Absolutely.
Okay, great, thanks.
Anybody else?
Thank you, Ms. Alexander.
I just need my glasses.
We turn to first to the administrative appeal. It is Bowery, 21921 LLC, 219-221 Bowery, AD 0077. Ms. Cruz, could you please present this case?
Good afternoon, board members. This administrative appeal seeks to challenge the determination dated August 4th of 2015, which denied the owner an extension of the code compliance deadlines. The staff recommends that the appeal be denied. Rules section 201B of the Law Board Rules requires that an application for an extension of the code compliance deadlines be filed before the deadline expires. An exception to this filing deadline is when coverage is granted or a building is registered as an IMD after the expiration of the code compliance deadline. When a building becomes an IMD after the code compliance deadline, the extension must be filed within 90 days after the coverage finding or the issuance of an IMD number, whichever is first. The owner here voluntarily registered the buildings on October 30th of 2013. After the relevant deadlines expired, the Loft Board issued an IMD number for the buildings on January 13th of 2014. Therefore, in order to file a timely extension application, the owner had to file the application within 90 days of January 13th of 2014. Instead, the owner filed the extension application on March 11th of 2015, more than 420 days later. In the appeal, the owner argues that the extension application is timely because the owner filed it within 90 days of a settlement in a coverage case filed by the tenants prior to the owner's registration. The owner argues that until there was a final outcome regarding the coverage application, the Loft Board could not issue the IMD registration number for the buildings. The owner's attempt to circumvent the filing deadline fails for two reasons. First, the Loft Board issued the IMD number based on the owner's registration application, not the tenant's coverage application. The owner's registration application was complete and not contingent on the outcome of the tenant's coverage application in any way. Second, if the owner wanted to preserve its right to challenge coverage after filing the registration application, it should have filed a contest application pursuant to Section 205 of the Loft Board Rules. It failed to do so. The determination dated August 4th of 2015, which denied the extension based on untimeliness of the extension application, was proper. The staff recommends that the appeal be denied.
Thank you. Thank you. Are there questions or comments about this? Is there a motion to accept this case? Mr. Delaney? Do I have a second? Mr. Shacker, thank you. Ms. Rivera, can you poll the members?
Still, Roberts,
Yes.
Chief,
Yes.
Chairperson,
Yes.
Yes.
Ms. Bullion Rivera? Yes. Mr. Shacklet?
Yes.
Ms. Shelley?
Yes.
And Ms. Davis?
Thank you. We turn next to the summary calendar. There are 10 summary cases. These cases are voted on as a group. They are Ranika Mukherjee, 134-136 Bowery, PO 0012. Cindy Boatwell Mead and several others, 258-270 Metropolitan Avenue, Brooklyn, TR 0882. Eric Richard Ushell, Kathleen Ann Luker, Therese Monica Paolini, and Sean Monahan, 324 Canal Street, TR 1071. Asa Clark, Anderina London, sorry about all this, Hikara Tezuka, and Nick Ambrosia, 1109 DeKalb Avenue, Brooklyn, TR 1117. Poonam Khanna Bastine and Paul Bastine, 57 J Street, Brooklyn, TR 1136. Samuel Anderson, 83-91 Meserole Street, Brooklyn, TR 1169. Jared Fortney, 104-106 Green Street, Brooklyn, TR 1178. Nicholas Locke, 7 Dunham Place, Brooklyn, TR 1206. Glenn Edwards, 360-362 Broadway, TR 1241. Mark Bloom, 360-362 Broadway, TR 1254. Are there any comments or questions about these cases? Mr. Delaney?
Yeah, I have questions on 3 of the cases. Number 5, 1109 DeKalb. The question is, this is, application is deemed withdrawn with prejudice based on a stipulation. The thing that's a little confusing is the stipulation is signed by 2 different attorneys than the attorneys that initially appear to have represented the parties, and there are no signatures of any of the applicants. I just wondered if we looked at that. Sorry.
It's okay. Usually it's better organized.
Was this the case with Endicott that filed this, signed this thing, or?
This was originally filed for the tenants by David Frazier and responded to by a partner of the ownership. And then we have 2 separate attorneys signing off on the stip. And it just
Who signed up?
a couple of the usual suspects. I'd say maybe Sandercock and the Rosenberg and Estes guy or somebody else.
Martha Sandercock?
Yeah.
She represents the tenants?
I didn't bring it with me either.
Yeah, she generally does.
Sandercock and Mr. Brody.
Brody.
Definitely the usual suspects.
Yeah. But it's just kind of, there are no signatures by the tenants, and so we went from, just seems a little, I don't know, a sketchy legal term?
The attorney.
We usually accept a signature from the tenants, from the representative of the tenants.
Okay. Most of the time I see tenant signatures too.
Right. I mean,
And you don't often see the attorney for the tenants as a signature to this, is that correct?
No, we've seen that a lot.
All right, okay.
Okay, you know what, if you would just take a look and make sure there's nothing
okay.
untoward.
And no nefariousness.
Pardon?
No nefariousness.
Whatever. Purely as a matter of interest, in the very thorough stip in case number 8, Mr. Fortney, 10416 Green Street, the board correctly notes that accepting the application as being is deemed withdrawn with prejudice and goes out of its way, as it should, to say it either accepts or rejects the remaining terms of the stipulation. One of the terms of the stipulation is the owner promised a C of O by January 1st of 2016. Do we happen to know if...
No, I don't know.
We don't know. All right, all right. And lastly, number 9, Nicholas Locke, 7 Dunham Place. Am I correct in reading this that the owner filed a registration application just for that one unit?
Yes,
Okay, and there are no other registered units.
I don't believe so.
So, okay, all right. Thank you.
Any other comments or questions about these cases? Is there a motion to accept these cases? Mr. Schachter, thank you. Do I have a second? Mr. Barowitz, thank you. Ms. Rivera, can you pull the members, please?
Mr. Barber,
Yes.
Chief,
Yes.
Chairperson,
Yes.
Mr. Denny,
Yes.
Ms. Golden Rivera.
Yes.
Mr. Schachter,
Yes.
Ms. Jones,
Yes.
7 in favor.
Thank you. We now come to the master calendar cases. We have 1 coverage case and 2 renewal cases. The first case is matter of Romano, 265-271 Douglas Street, Brooklyn, TR 0906. Ms. Cruz, would you please present this case?
On May 23rd, 2011, tenant in third floor unit 269 Douglas Street filed an application seeking findings that the buildings located at 265, 267, and 269 Douglas Street constitute a horizontal multiple dwelling and is covered pursuant to 281.5. In order number 4260, the law court found that the building is a horizontal multiple dwelling and remanded the application for a determination on the claim for Article 7C coverage. In her report, Judge Lewis recommended that the coverage be denied because tenant failed to prove that there were 3 units residentially occupied for 12 months during the window period. The staff recommends that the board accept Judge Lewis's recommendation. The